Yes.
Sir, we'll wait for 5 minutes. Just as Chatterjee Jay will join. 5 minutes.
Yes, Lordship.
The wooden chair near the swing. Earlier, I used to have near the shoe rack. Yes, yes, Mr. Bose.
My lord, may I have your lordships kindly to mention a matter upon notice. This is that gold matter, 4 kg gold. If your lordship recollects, my lord, there's a proceeding which has been initiated by us.
Yes.
By which, my lord, against an order, in terms of an order, by which your lordship was pleased to confirm the order of the tribunal for provisional release. Now, the department has been saying that they want to go before the Supreme Court, so they have taken repeated adjournments, and an application for appropriate order was also passed, which was rejected by your lordship on 5th of May. Now, my lord, what is happening is that now they've issued a show cause. They are proceeding with the show cause. Now, my lord, so effectively, what they're trying to do is that, my lord,
to make the order unworkable.
Yes, absolutely, my lord. I was
so you move an application, we list it tomorrow.
My lord, deeply obliged, my lord.
Tomorrow.
Grateful, deeply obliged.
Please inform Mr. Udeshakar Bhattacharjee. And
I will.
Any central government panel council is here?
Yes, my lord. They are here, my lord.
I'm here, my lord. Manasi Mukherjee.
Manasi, you please inform Mr. Bhattacharjee that in case we find, we may initiate suo motu contempt also.
My lord.
There are two ways. Either you challenge the order, get it set aside. Some diary number also they did not give on the last occasion. Yet we said that judicial propriety demands that we don't pass an order. We don't take up the matter. And we have, on what date have we adjourned the matter?
Well, your lordship, 13th of June.
13th June. So in the meantime, if you are trying to adjudicate the show cause notice, either you comply and adjudicate.
Absolutely, well. Or there should be stay of the adjudication process till they comply with the order.
You have got sufficient time.
My lord.
Whenever we say that you complete adjudication, you will say, no, as per the act, we have got 6 months time, 3 months time. That will be the stand taken by the department in several matters. This is unfair. You get file an appeal, obtain a stay, or you set aside the direction, there is no issues. So the department can't outsmart the court, no? We have been very indulgent to the department on several occasions, especially in condoned delay matters. Despite severe objections, we affidavit in opposition, we have condoned 300, 400 days delay. So that indulgence we have shown. All right, there will be a lot of factors by which the department may not be able to do. But this is trying to be too smart. You can ask Mr. Bhattacharjee to inform the concerned commissioner that tomorrow the application will come up, then court may take serious note of it.
Miller.
Grateful, Miller.
Thank you.
May I be permitted, my lord, to mention one matter, my lord? Yes. Item number 30 of today's list, my lord, under the compelling circumstances, I am mentioning it, my lord. This matter has been running in your lordship list for the last 2 weeks. My lord, it could not be taken up because of the paucity of time, my lord, but my problem is, my lord, the contempt petition has already been, contempt proceeding has already been initiated. Matter is fixed on 22nd, and on 2nd of May 2025, the learned single judge has already passed an order directing us to show cause as why it has not been complied with, despite the fact, my lord, we have stated that the appeal has been filed, my lord, along with section 5 application, my lord, condonation of delay. So if it can be upgraded, my lord, taken up.
Who appears for the...
Yes, upon notice. Mr. Partho Ghosh is appearing, my lord. It's upon notice. In fact, my lord, he also served a notice yesterday on me for mentioning this matter. And I have also served, my lord. If it can be fixed at any...
No, we will upgrade it tomorrow.
Grateful, my lord. Grateful, my lord.
Grateful. Please upgrade it tomorrow.
Yes, lord.
My lord, similar pair in my application. Item number 32 is running to today's list. Eastern versus Emirate versus Mongolian.
So, item 30, 31, 32 are all similar matters.
Lordship.
So, all right. All the 3 matters you please upgrade.
Yes, lord.
Yes.
Madam, you please inform the...
Yes, I have already informed by email.
Well, I am here, my lord.
He is here.
4 matter, my lord, not 3, my lord.
4 matter.
4 matters, my lord. All Eastern Coalfield 4 matters, my lord.
One appeal is by the writ petitioner, I think. Item 30.
Yes, that is last one, my lord.
What is the issue?
My lord, the issue is, my lord, in respect of the first matter, my lord. Here, my lord, the compensatory employment as well as, my lord, the monetary compensation, my lord, is as per the provisions I am entitled to. That was ordered by the single judge with interest.
and against that order, my lord, they preferred appeal, my lord.
All right. What
Now
is
my
I 33?
33, that is, my lord, the person was, my lord, his candidature was rejected on the ground of, my lord, eye defect, and that was, my lord, tested by the, my lord, independent medical board, and medical board found me, my lord, for fit for employment.
33 is not connected with 30 to 31.
The last two matters, my lord, connected, my lord.
32.
That
All
is
let all the 4 matters be upgraded tomorrow.
grateful, my lord.
grateful, 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 sir.
Immediately after the fresh application.
Grateful to you, sir. Grateful.
Milord, Milord, may I pray Milord's kind leave to allow the filing of the appeal in a casta matter, Milord, as the cause title as it is basis. Milord, the memo has already been filed and allowed. Milord, the stay application and condonation of delay includes only the details of the impugned order in the cause title. So that is the thing, Milord.
All right, leave granted.
Milord, deeply obliged, Milord.
My lord, I am with your lordship's kind leave. My lord, my lord might recall I had earlier mentioned this batch of matters, my lord, regarding the Ponzi bench. The honorable lordship had given a clarification. Now, my lord might recall the pressing situation of this application is that the degree conferment ceremony is on 2nd June during the vacation. Now, my lord, it appeared before the honorable Ponzi bench. The honorable Ponzi bench was of the view it came before court number 759, not the Ponzi bench which is sitting at court number 238. However, their lordships had kept all these matters under the heading to be mentioned for placing all these matters after the vacation. Now, my lord, I pressed before their lordships for their lordships were of the view that the clarification has just come and it would not be possible for them to take up these batch of matters, at least my matters, before the vacation, in spite of being apprised of the situation that 2nd June is the date for conferment of degree. Now, your lordship, under this circumstance, their lordships were pleased to release these matters from their lordship's list, my lord.
I will. You go to the OSD.
Lordship.
Give a copy of that letter. I mean order.
We have communicated the letter, your lordship, on 16th May itself. 16th May it was released. These batch of matters were released. We have placed before the learned OSD by a letter.
Today the assignment will be done.
Deeply obliged, my lord. Deeply obliged.
Lordship, may I be allowed to mention, Lordship,
So
item
you
number?
please inform the OSD mentioning.
Yes, immediately I take it up with the OSD.
I will make the assignment order today.
Deeply obliged. Deeply.
Friday, I was on official duty elsewhere. I was traveling. So therefore, he would not have placed. Up to Thursday night, we have cleared everything.
Yes, deeply obliged.
Lordship, may I be allowed to mention item number 76 of the monthly list, Lordship? This is very urgent, Lordship. I had mentioned on 13th upon notice, Lordship was pleased to allow, Lordship, upgradation, but not yet upgraded, Lordship.
Please check up.
The appeal will become infructuous, Lordship, if not taken urgently, Lordship.
Please give
Appellate side.
item number
76 of monthly list of May.
56. Please upgrade.
Milords,
Grateful, Lordship.
may I have Milords leave, Milords? The Manrega matter, Milords had indicated this week, Milords wanted to take it up, Milords, for hearing. Would it be Milords' pleasure to indicate a date, Milords?
We will find out. Tomorrow I will give the date.
I'm grateful, Milords.
Lordship.
Upon notice, Lordship. Upon notice, Lordship, may I have your Lordship's kind leave to mention a matter for extension, Lordship, extension of the interim order. Lordship, the interim order is coming to an end today itself, Lordship. Lordship, kindly be pleased to.
You could have mentioned it on Thursday.
It's Lordship, this matter, Lordship, was mentioned in the last week also, Lordship. Upon Lordship, I'm having the
Matter or original side matter?
Lordship, kind pardons?
Appellate side or original side?
Appellate side, Lordship. Appellate side. Interim order is coming to an end just today itself, Lordship. Lordship kindly permits to.
Tomorrow.
Lordship, may I have your Lordship kindly leave to mention one matter for inclusion of the list. This is an application matter. Lordship, the instant appeal has been filed by challenging the order passed on 21st February 2025. Lordship, which is passed in contempt jurisdiction. Lordship, the writ petition was disposed of by direction was given to the corporation to absorb the respondent from the service who is just a casual employee. Lordship, while disposing of the contempt application, the single bench was directed the absorption with retrospective effect, which could not have been directed in the contempt jurisdiction. This is the urgency. Kindly include this matter in the list.
Yes. Please give the number. We'll
I'm
include.
grateful, Lordship.
Yes, madam.
Yes, madam. So I'm a citizen of Kolkata. I live in Beleghata. My name is Dr. Anuradha Das. I have been subjected to a lot of physical assaults and damage to my property inside the premises. And 7 of my CCTVs were damaged on the 3rd of December. Previously, they have done lots of these damages in my property. And the case was filed in Beleghata PS. But no action was taken to retrieve my CCTVs, following which they have damaged much of my properties. I had filed a case of police inaction, case number WPA 5696 of 2025. But even after that, the order was passed on 26th March 2025. But that has not had any effect on these persons, and they have again damaged on the 10th of May. They have damaged they have broken the terrace door and damaged all the CCTVs over there, and they have also damaged the collapsible gate and everything, and they are going on a rampage like this. And Beleghata PS is not taking any action regarding that. So now my life is at stake, sir. Now they are going to break my door, and they are doing it without any compunction, and no restraint whatsoever. Now I don't even have the CCTVs. 9 CCTVs have gone totally, and my life, I live alone. My life is at stake now.
Please hear.
Yes, sir.
You had filed a writ petition in WPA 5696 of
2025.
Yes, that has been disposed of by an order dated 26th of March 2025.
Right.
There are two remedies available to you. If, according to you, you are dissatisfied with this order, you can file an appeal. In fact, Mr. Rajdeep Mazmundar, who is the present, I think, deputy.
He was not present, sir. He was not present. I was very badly represented. His name is here, but he was not there. If you see the CCTVs of that.
Madam Das, please hear.
Yes, sir.
So if you are dissatisfied with this order, you have to file an intra-court appeal. It will go before a division bench having determination. You can engage an advocate of your choice or appear party in person. On the administrative side, as a Chief Justice, I cannot do because the writ petition has already been disposed of. That is why the Secretary requested you to go to the High Court Legal Services Committee, but it appears that you are not convinced with the advice given. What can we do, madam?
Sir, I have come to you because my life is at stake. Even for immediate help. The administration, even I've written to the CP that I want to sit with him for a hearing, but he has not complied. So I have come to you for some sort of
Madam,
the CCTVs, and these people are still there doing all this, but they are not being taken to prison. They are not under bars. They are openly doing this thing. Beleghata Thana knows everything about it. So am I going to be beaten up by them? They have already beaten me up many times. Am I going to be beaten up by them all the time, or even my life taken? They are threatening me that all the doors they are going to break up. Openly doing all this thing.
In fact, in page number 3, there is a direction issue that the Kolkata police is having this cell. That
does not work. So even I told the Honorable Court that day on standing over there, I told him the pronoun does not work. I am a member of pronoun. Pronoun does not work, sir. And the same thing has occurred again. Pronoun does not work.
All right. Then you file an appeal against this order. I will direct it.
I can file an appeal, but immediate help I'm not getting. My coming and going, they are putting CCTVs in their place, unauthorized and illegally. And they're monitoring my going and coming.
That's on the merits of the matter. On the administrative side, as a Chief Justice, I cannot interfere with this order. You can file an appeal the appellate court will consider, it will call for a report from the CP, they'll do it. You can
That's a
engage.
long time.
No, it won't take long time. Now, if you are agreeable, we will directly send you to the Secretary of the Legal Services Committee. He will nominate a lawyer today. He will draft the petition and he will file it.
I went there. The secretary of this High Court, Mr. Ajay, sent me there. But that person who was sitting there told me that he cannot help me.
Why?
I went day before yesterday. This court was closed.
Then why did he say he can't help you?
He said no. This sort of case, he doesn't know anything about this guy. The lawyer who was sitting there, he told me that. I went there. My name is entered over there.
You have to request him to allot a lawyer from the panel, and then you have to approach that concerned lawyer.
He knows his job. What can I tell him? Sir, immediate help I need. My life is at stake. That is why I have come on this virtual.
আপনি আজকে যান না, জজ সাহেবের কাছে মেনশন করেছেন না, আপনি আজকে যান।
But normally they will not say like that. They will definitely allot a lawyer. Very surprising that you are saying that he doesn't know his job.
No, I am not suppressing, sir. I went to him. He told me this sort of cases he doesn't look into. That's what he said.
Why? Because you are not entitled for free legal aid.
Agree what, sir?
Free legal aid. Are you not entitled? Are you working somewhere or you are a pensioner?
I'm 72 years old.
No, are you a pensioner?
Yes.
You are working in which department?
But part pensioner. I'm an oncologist. Health and family welfare.
So the problem is, madam, free legal aid means there is an income ceiling. Suppose your pension is more than that, free legal aid will not be. But if you want, we can ask some lawyer who's here. Amrita Pandey, you can help her. You can help.
Sir, I want relief. I don't know who will give me the relief because somebody told me about Mr. Rajdeep Majumdar. So I went to him.
We are saying unless you approach the court, no relief can be granted. On the administrative side, as a Chief Justice, I cannot say to the police, do this, do this. You have already approached the court. There is an order. This order you are dissatisfied. The manner in which you are to agitate the correctness of this order is to file an appeal.
Your Lordship, I'll guide my all right.
Please take the assistance of Ms. Pandey. She will be able to help you.
Thank you.
2 minutes. Your Lordship, I'm mentioning a matter wherein the Honorable Single, in Group 6 matter, Honorable Single Judge has directed for release of the monetary claims without any verification, as whereas in our company, it is mandatory, a police verification has to be done before the release, and this matter is around 40 years old, the claim. Your Lordship, so on this small point, the appeal is there, Your Lordship.
You give the number, it's a fresh case.
Sincerely obliged.
Notice has been served.
Your Lordship, I had served a notice a day before yesterday for Friday. I'll serve again, Your Lordship, that today matter was mentioned.
No, you serve again and also serve on the advocate who appeared.
Your Lordship, Ms. Tanushree Dasgupta had appeared. I'll serve her.
You serve her.
Obliged, Your Lordship.
Please call.
Original side, Delhi is matter item number 1.
How many days?
I beg to appear on the appellant, my lord. There is a direction, my lord, to serve upon the SSC by my lord mail. My lord, we have served upon the my lord SSC through mail.
468 days delay, my lord.
468.
ট্যাক্স এফেক্ট অনেক টাকা আছে পেনাল্টি প্রসিডিং অনেক টাকা ট্যাক্স এফেক্ট আছে আছে যে 1.8 এর পর আমরা কোনো প্রসিড করি 148 এর পর ওইটুকু ইনস্ট্রাকশন দিতে বলেছিল আমাদের যে আমরা ফার্দার প্রসিড করেছি কিনা আর 3 নম্বরটা এক্সটেনশন সেটা এক্সটেন্ড করে দেবে কি না
So this is a case of enhancement of penalty.
Yes, my lord, that is my lord, where my lord the CIT appeal had hold. But initially, my lord, it was a penalty imposed my lord on the ground that my lord, the loan that has been repaid, my lord, that was not as per the provisions of section 26090.
And who appeared for the SSC? Sachit Jolly, along with Sri Rohit Garg and Murnal Parekh. I think this is from Mumbai.
Yes, my lord.
Then you let us wait for some time. What happened to the original notice sent?
But original notice, my lord, it has been, my lord, SSC had not been located. Thereafter, my lord, upon the direction of the Honorable Court, we have served, my lord, through mail to the SSC's registered email.
Then you do one thing. You serve the notice on the SSC through the Income Tax Department at Mumbai.
My lord.
Because the assessing officer, where is the assessment order? Why did it go to Mumbai? Where is assessment order is at page 18, is it correct?
Yes, my lord.
Yes, starts from page 14, my lord.
No. Sir, page 12 is assessment order of Gold Line Trackcom.
The Gold Line Tradecom, my lord, amalgamated to, my lord, the SSC, Mita Holding.
But the assessment was at Kolkata. Then yes. How did it go there?
Their, my lord, office has been shifted to, my lord, Mumbai.
And who's the jurisdiction officer who will scrutinize his returns?
SSC address
additional CA.
One of the address of the SSC was originally at Calcutta. Then the SSC shifted to Mumbai.
You come to page 40, Mr. Mitro. 40, annexure B. Got it?
Annexure B, my lord.
Fourth column. Name and designation of assessing officer who made the assessment order. additional CIT, Circle 3, Mumbai.
Yes.
You serve notice through him.
My lord.
The notice sent to the assessee had returned with the postal endorsement, addressee left. Therefore, on the last occasion, direction was issued to the department to serve notice on the assessee through email, which appears to have been complied with. However, none appears to the assessee. Initially, the assessee company had the registered office in Kolkata and subsequently had shifted to Mumbai. The assessing officer is the Additional Commissioner of Income Tax, Circle 3, Mumbai, whose order was put to challenge before the Commissioner of Income Tax Appeals, 51, Mumbai, and the matter travelled to the tribunal at Mumbai. Therefore, we direct the department to serve notice on the assessee through the office of the Additional Commissioner of Income Tax, Circle 3, Mumbai, or the present assessing officer of the assessee at Mumbai. List after 3.
I'm grateful, my lord.
Item number 2. I'm appealing for the appellate, my lord.
What happened?
There was a direction to serve on the assessee through department, my lord. The department had sent an inspector to serve the notice, but assessee was not found. So service was effected through affixation. Yes, lordship. Through affixation, it was done. I have a email from the department regarding this.
Take down. We have heard Mr. Amit Sharma, learned senior standing counsel for the department. In terms of the order passed by the passed on 23/4/2025, the notice was attempted to be served on the assessee by the inspector of the income tax department, but however the assessee was not found, and therefore notice has been served by affixation, and a communication in this regard has been given by the officer, which is taken on record. There is a delay of 100 days in filing the appeal. Since the delay has been explained, the same is condoned. Application allowed.
My lord, the issue is regarding reopening. The tribunal held that there was no justification for reopening, and reopening was done mechanically. Lordship, this case is covered by the your lordship's recent order in PL Goenka's case, my lord. IT 8241 of 2024. The finding is at page 19, my lord.
Where is the assessment order?
Assessment order is at page 10.
Yeah. In fact, he has been given an opportunity to explain.
Yes, lordship. But the tribunal is of the view that the reasons for which the matter of the case was reopened was not justifiable. It is mechanically done. My lord, kindly come to page 20, para 8.3. Considering the above facts in light of the ratio laid down in the above decision, we are of the view that in the present case also the AO has reopened the case on very vague reasons without recorded objective satisfaction. My lord, if you come to page 18, my lord, it contains the reasons given by the assessing officer.
What more do they want? Can you ask the court officer to share that judgment on screen?
Lordship, 241 of 2024. PL Bank.
The appellate CIT appeals order is a ex parte order.
CIT orders page 12.
None appeared for the SSC or for the department. Sir, please take down. This appeal has been filed by the Revenue under Section 260 capital A of the Income Tax Act 1961 against the order dated, challenging the order dated May 3, 2024, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket tribunal, in ITA number 574/KOL/2022 for the assessment year 2010. The Revenue has raised the following substantial questions of law for consideration. Page 5 of the state petition, page 5 and 6, 1, 2, 3, 4. We have heard Mr. Amit Sharma, learned senior standing counsel appealing for the appellate. As noted above, despite service of as noted above, the assessee has not appeared in the matter. We have carefully considered the finding rendered by the learned tribunal while allowing the assessee's appeal and setting aside the reopening of the assessment as done by the assessing officer by the order dated 15/12/2017 under section 143 and 147 of the Act. The only ground on which the learned tribunal has allowed the assessee's appeal is by holding that that the assessing officer reopened the case on very vague reasons without recording objective satisfaction as to how the income has escaped assessment. To test the correctness of this finding, we have carefully perused the assessment order dated 15/12/2017. The case was reopened on the ground that the assessee's bank account was credited with ₹1 crore from Messrs. Rupak Developers Private Limited during the financial year 2009-10, and accordingly notice under section 148 was issued on 29/3/2017. In response to the said notice, the assessee filed the return of income on 17/4/2017. Full stop. Notice under section 143 within bracket 2 of the Act was issued to the assessee on 16/8/2017, and notice under section 142 within bracket 1 of the Act was issued along with the questionnaire was issued to the assessee on 14/7/2017, calling upon the assessee to submit details and documents to substantiate his return of income. In response to such notices, the assessee was represented by his authorized by their chartered accountant, but the assessing officer has recorded, don't say chartered accountant, and the assessing officer has recorded that the assessee, though appeared through authorized representative, could not submit or produce or explain the allegation against him, nor could produce any details or documents. Furthermore, am I audible, sir?
Yes, sir.
Yes, Lordship.
Further, the assessing officer would state that from the records seen that the assessee got rupees 1 crore from Messrs. Rupert Developers Private Limited in the relevant financial year as a beneficiary in the form of bogus LTCG/STCG. Furthermore, the assessing officer had material to show that Messrs. Rupert Developers Private Limited was actually used providing accommodation entries to various beneficiaries in the form of bogus LTCG/STCG on sale of shares. Since the SEC could not prove the genuineness of the transaction, the business rationale with supporting documents, the assessing officer took a decision against the assessee and treated the sum of rupees 1 crore as unexplained. From the assessment order, it is seen that though sufficient opportunity was given to the assessee to explain the fund transfer in the bank account, no explanation was forthcoming. Accordingly, the assessment was completed. Therefore, it cannot be stated that the assessing officer did not apply his mind, nor the reasons given for reopening could be stated to be vague. The reasons for reopening have been noted by the tribunal. Which state that the information is in possession of the department in respect of Messrs. Event Developers Private Limited, the assessee, from which it is revealed that the assessee has received rupees 1 crore on 28/8/2009 from the current account of Messrs. Rupert Developers Private Limited. Further, the reasons state that through survey operations carried out on 9/6/2018 by the Mumbai Directorate within bracket investigation in the case of Messrs. Rupert Developers Private Limited, it was found that no business activities are carried out by the said company and is being used for providing accommodation entries to beneficiaries in the form of bogus LTCG/STCL on sale of penny stock. Therefore, the reasons have been clearly set out, and the assessee having filed the return of income pursuant to the notice issued under 148 had sufficient opportunity to give their explanation to the reasons so recorded. The assessee did not avail this opportunity. When the assessment was taken up under section 147 of the Act, the assessee was issued notices along with questionnaire, and the assessee was represented by a chartered accountant, but no explanation was offered. Therefore, it is not a case where the assessing officer did not apply his mind, but has recorded his satisfaction upon considering the material available with the department. When the assessee carried the matter on appeal before the Commission of Income Tax Appeals to Calcutta within bracket CATA, though certain grounds were raised, the assessee did not pursue the appeal. The appellate authority, while rejecting the appeal by order dated
Appellate order, Lordship. 2nd April 2019.
2nd April 2019. Yes, date of appeal. Has noted the various dates on which the case, the appeal was adjourned from April 2018 to March 2019. the CITA also took note of the reasons given by the assessing officer and affirmed the said order. Therefore, in our view, the tribunal fell in error in coming to a conclusion that the assessing officer has reopened the case on very vague reasons without objective satisfaction as to how income has escaped assessment. The assessing officer, sir, please scroll down, sir. Which would be the relevant paragraph, Mr. Amit Sharma?
Paragraph 9, my lord.
Please come to para 9.
Yes.
In a more, please, next para. More or less an identical circumstances arose in the case of so-and-so, IT-80 number so-and-so, and by judgment dated so-and-so, the appeal filed by the department was allowed. In the said judgment, the following observations / findings were rendered. Then para 9, then go down, please. I am not able to scroll.
Paragraph 9 to 12, my lord. 12 is 12.
9 to 12 you extract. Next para. Thus, for all the above reasons, we are satisfied that the assessing officer had reopened the assessment with due application of mind. The reasons which have been recorded for reopening cannot be construed to be vague. Apart from that, the assessee miserably failed to establish the genuineness of the transaction, the creditworthiness of the company, namely Mrs. Rupak Developers Private Limited, who are found to be a shell company with no business activities. And therefore, the creditworthiness of the said company has also not been established. Thus, all these factors would go to show that the reopening was done for valid reasons, and therefore the learned tribunal ought not to have interfered with the said order, assessment order. Accordingly, the appeal filed by the revenue is allowed. The order passed by the tribunal is set aside, and the assessment order stands restored, and consequently restored. Full stop. The substantial questions of law raised are answered in favor of the revenue. Next.
I'm grateful, man.
Item number 3.
Respondent.
These matters, my lord, perhaps service has to be made because it has been returned.
Fresh notice to the respondent, returnable in 2 weeks, 3 weeks. In addition, notice shall be served through the registered email ID of the assessee, and also by deputing an inspector of the department to effect personal service. Next.
Lord, we have filed the affidavit of service.
Affidavit of non-service. How can it be affidavit of service?
Item number 4.
We have served them.
I appear for the respondent.
There's deal of 86 days, Mr.
86 Kejriwal won't object.
I'm appearing this.
Mr.
My lord, only one thing here, my lord. The tribunal has passed a consolidated order for the assessment of 1516 and 1617. My lord, 1516 is IT-80 number 72. My lord, that has not been listed.
Yes.
So we will today condone the delay, list it along with IT-80 72.
My lord.
Yes.
My lord.
The word so-and-so. There is a delay of 86 days in filing the appeal. As the delay has been properly explained, the same is condoned. GA1 number 1 of 2025 allowed. List this appeal along with IT-80 72 of 2025. Next.
Grateful.
Item number 5.
Grateful, madam.
My lord, and item number 5, I appear for the respondent.
My lord, this is a similar case.
62 days.
My lord, delay had been condoned already.
No. Not
No,
condoned.
no, this is the first time, my lord, this matter is appearing, my lord. You, my lord, may condone the delay. My lord, the another matter of, my lord, the same SSC, that is, my lord, also appearing before your lordship today, that being item number 24 of your lordship. In that matter, my lord, delay has been condoned.
Okay.
So, my
We
lord,
have heard so and so. There's a delay of 62 days. As the delay has been properly explained, the same is condoned.
My lord, may kindly take 24, my lord. Item number 24.
Not today, sir. Let him get ready.
My lord, I think he's ready.
List this appeal along with IT 177 of 2025 on Friday.
My lord.
My lord.
Item number 6.
I'm grateful, my lord.
Item 6.
My lord, notice served. A delay of 166 days.
Mr. Agarwal appears.
My lord. My lord, in this case, I have not received wakalatnama, and on merit, I would require paper book also, which was filed before the tribunal. So, delay may be condoned, and for consideration on merit, it may be fixed on some other day, my lord.
We have heard so and so, so and so. There's a delay of 166 days in filing the appeal. As the delay has been properly explained, the same is condoned. Application in GA1 of 2025 is allowed. Liberty is granted to the respondent assessee to file the paper book, which was filed before the learned tribunal.
I'm grateful, my lord.
You give a date after vacation. Same order for the next item also.
Item number 7.
7 also same 166 days.
166.
Then next.
Item number 8. Item number 8.
I am appearing, my lord.
Served respondent. No. Have you served notice?
My lord, Mr. Bhattacharya is happy, my lord. In this matter, on advocate on record. Lord, may I just make it a passover, my lord? He's on his
What we'll do is we'll list it, list after service of notice on the respondent.
Grateful, man.
Item number 9.
My lord, I am appearing for the respondent assessee, my lord. In this matter already for the assessment year 2013-14, this is the year for 2017-18. Your lordship already decided the issue because it is not maintainable. Because this assessee already under the CIRP proceedings and resolution plan has been completed.
Where is that order?
Already I am spared the order in the mail, my lord. That is the IT-80 number 147 of 2024. This is the order dated 24th of May 2024, my lord. I am already shared in the mail, my lord.
All right, let them open. Who will appear for the department?
Mr. Somen Bhattacharya, he has served the copy of the
item number 9. Item
9.
Yes. Look, item number 8 and 9, Lord, I am appearing.
8 and
8 we have marked your appearance, you adjourned it. Item 9. 9, Mr. Basu says it is covered by the assessee's own case.
For the assessment year 2013-14, my lord. This is the year of 2017-18 assessment year.
All right, we will do one thing. We'll list it on Friday. Today we'll condone the delay alone.
My lord, it is not maintainable at all. So only adjourn.
No.
Delay may kindly be condoned.
Delay has to be condoned, then only we can say it is not maintainable. There is a delay of 159 days.
As your lord.
As the delay has been properly explained, the same is condoned. GA1 of 2025 is allowed. List the appeal on Friday.
But may I file the affidavit of service?
You please send a soft copy to Mr. Bhattacharya, that judgment.
Definitely, my lord.
Item number 10.
10.
Number 10. 10, my lord, I am appearing.
Well, I am for the respondent assessee, my lord.
We can condone the delay, Mr.
Yes, my lord. 165 days delay in filing.
165 delay condoned. Next.
Item number 11.
হবে
11, my lord, I'm appealing.
I'm for the respondent, lordship, in this matter.
Yes, sir.
My lord, there's a delay of 112 days.
All right, condone.
Anjan Babu.
Sleep time.
Well,
Here, here.
12 minutes, there is a delay of 85 days.
Mr. Agarwal appears.
Yes, my lord.
All right, delay condone.
13 minute delay of 200.
Milord 13, I'm appearing for the respondent, Milord.
13th, Mr. Bagh, you are appearing.
My lord, for the respondent, Milord. There's a delay of 122 days, Milord.
We'll condone that.
I leave it to your lordship.
All right. Delay condone. Next.
Item number 14.
My lord, I appear for the respondent in this matter. My lord, there is a delay of 594 days, and I am strongly opposing the condonation.
Exactly.
Because this is a case of zero explanation for the delay, when from the same judgment, I have preferred an appeal in the year 2023, which has been contested by the state, and paper books are ready in that appeal. So there's no explanation at all why there is a delay of 594 days in preferring an appeal from the same judgment, from which I have also preferred an appeal in 2023. Well, the only explanation given is that they have received an opinion from the Learned Advocate General in February 2025, whereas the Learned Advocate General was appearing in the court below at the time when the matter was finally heard, and he also appeared in my appeal on the day it was admitted.
Now, this is a group 9 matter, sir. Is this a group 9 matter?
Millard, this has been classified by me. I'll tell you, Lordship, this has been classified by me as a group 9 matter, but I have a submission on that, Millard. If your Lordship looks at the rules, 226 rules, it's really a group 4 matter because it is squarely covered by the entry K, which is levy and short levy of duties, and this concerns stamp duty.
Stamp duty.
So therefore, this is a group 4 matter, although wrongly classified as a group 9 matter. So my humble submission is that your Lordship
No, the single bench was heard by a group 4 judge or a group 9 judge?
The single bench considered it as a group 9 judge.
Then unless the presentation form is amended in the writ petition, then they will raise a issue saying that because your other matter, your appeal would have gone before the division bench dealing with group 9 matters.
Yes, yes.
So though it is a stamp, at the appellate stage, we can't treat it as a group 4 matter.
Millard, in that case, Millard, may I have the leave to amend the presentation form?
That will be a long drawn process, sir. They will oppose and all the.
Or Millard, because it is in substance, or rather, it is strictly a group 4 matter. Your Lordship, perhaps in your Lordship's administrative capacity, assign the appeals to your Lord.
The problem
because this is really a group 4 matter.
Actually, it is no doubt true. It involves the proceedings under the Indian Stamp Act.
Yes.
Ultimately, it's the levy of stamp duty.
Yes.
But technically, if you see the classification determination roster,
yes,
that is slightly different. See, appeals relating to revenue under Group 4 and other statutory revenue appeals,
yes,
except land revenue,
yes,
and applications connected thereto. Matters relating to direct and indirect taxes, including applications.
Yes.
So, it does not relate to a revenue as such. The respondent will be the authority under Section 47.
Yes. Yes.
So we will say, let it be listed before the Honorable Division Bench dealing with appeals arising out of Group 9 matters. Tomorrow it will appear.
Very well.
List this appeal before the Honorable Division Bench dealing with intra-court appeals arising out of orders passed in writ petition filed under Group 9.
Gotcha.
Thank you. Next.
Item number 15.
My lord, in this matter, my lord, Mr. Sanjay Bhaumik is appearing for the appellant. My lord, this is a appeal filed under Section 49 of the Benami Act.
Now we have constituted a special bench. Yesterday, did you see the notification? Friday.
My lord, I am not aware of that. My lord, I
No,
had.
you have to open the website, sir. It won't come to your house.
My lord, I got a copy of the order. My lord, that I have. Last order was that I mailed it.
No, you please see. It will go before the. I have constituted a special division bench. Arising out of Benami Transaction Act, Prohibition Act, then SAFEMA, and all other appeals being dealt with by the appellate tribunal under SAFEMA.
My lord.
List this appeal before the Honorable Division Bench having determination.
My lord, I'm grateful.
Item number
Yes.
16.
16 delay has already been condoned, sir.
Yes, my lord. Delay
My
has
lord,
already been.
my lord, I am to place the paper book before my lords, which was filed before the ITAT. So let it be adjourned today because I am unable to place the paper book, my lord.
We have heard Mr. So-and-so, so-and-so. Learned advocate appearing for the respondent request time to file the paper book which was filed before the learned tribunal. List the matter on so-and-so day. Let advance copy of the paper book be served on the learned advocate appearing for the appellant department. Next.
Item number 17.
Appearing on behalf of the respondent, Mr. Prithu Duduri has to appear on behalf of the department, Your Lordship.
Who has to appear?
Mr.
Prithu Duduri.
I'm just coming. My lord.
All right. Today at 12 o'clock, we are supposed to take up appellate side matters.
After vacation, if it may be convenient, I'll prepare a list of dates. It'll be more convenient for my lords. Because the same assessment or same assessee was before my lords previously. Now that list of dates, if I prepare, it'll be convenient for my lords.
List after vacation. The learned advocate appearing for the respondent is granted leave to prepare a list of dates and events. And let a copy of the same be served in advance on the learned advocate appearing for the appellant department. Next.
Item number 18. Item number 18, my lord, I am appearing.
May it please your lordship.
Respondent, Mr. Jinjanwala.
I'm appearing, Your Lordship.
Any short matter is there?
Well, item 19 is short, my lord. It's below tax effect. Item 19.
Hong Kong Dragon Airlines.
That's below tax effect, Your Lordship. Some 11 lakh rupees. Mr. Sharma is appearing in that matter, Your Lordship.
Item 18 to
Millard, we have taken instructions from the department. Millard, it is below tax.
They had made some calculation mistake.
All right. Item 19, ITA 52 of 2025. Appeal has been filed by the department under Section 260 Capital A of the Income Tax Act, challenging the order dated 9th January 2024, passed by the Income Tax Appellate Tribunal C Bench, Kolkata, in ITA number 419/KOL/2023 for the assessment year 2016-17. The revenue has raised following substantial questions of law for consideration. Page number 8 and 9, 1, 2, 3, 4, 5. We have heard Mr. So-and-so for the appellant department and Mr. So-and-so Jinjawala appearing for the respondent assessor. It is not disputed by the revenue that the tax effect involved in this appeal is below the threshold limit fixed by the central board. If that be the undisputed factual position, the department cannot pursue this appeal any further. Accordingly, the appeal stands disposed of on the ground of low tax effect, and consequently, the substantial questions of law suggested are left open.
Millard, may I file, Millard, the written instructions which we have received?
Written instructions given by the department is placed on record, taken on record.
Item number 18, my lord, is adjourning it.
After vacation.
After if your lordship, grateful, my lord.
Grateful, Your Lordship.
20.
Grateful, Your Lordship.
Item 20. And I'm appearing for the respondent in item 20. Lord, in this matter, the delay was condoned on the last occasion on 23rd April 2025. Lord, we had handed over, Lord, copies of judgments Lord, in Abhishek, Buildwell and Phalguni, Lord, because the point here is, Lord, whether the
Then
conditions.
we'll do, Mr. Bhatt,
Lordship,
let it remain in the list.
yes, my lord.
Lordship.
No, not today.
Item number
Deeply
21.
regret.
But 21 also, my lordship will make it not today, my lord.
Not today.
I'm there for the response.
22 delay already unknown, my lord. But
My lord, 22.
here
I'm
my,
saying. My lord,
22.
let a date be fixed, my lord.
no, my lord, this is a very short matter and it is below monetary limit.
Please show.
My lord, here addition made, all addition under 68 cannot be treated as accommodation entry. Here the allegation is client code modification. If your lordship see the assessment order, all facts are dealt in the ITAT order. Limit is, my lord, 27,83,000. Client code modification is the allegation. If your lordship kindly see, my lord. Date चाहिए. Moreover, my lord, last occasion I said that 147 was done after limitation period. Your lordship kindly see page 41, para 3.
My lord, the finding starts at page 42, my lord.
Para 5.
Yes, my lord. Para 5.
But the client code modification, there is no allegation that the assessee did it.
No, my lord. Yes, it is true. SSC did it.
No.
SSC did not do it, but their allegation is like this, but there is no proof also.
See,
there is
broker has done this mischief, but there was no material to indicate that the assessee colluded with the broker to do this.
Yes, my lord.
My lord, in this case, the information was received from the SFIO, Serious Fraud Investigation Office.
That is, lordship, beyond the period of 4 years. That is
That
covered
I
by the
submitted.
147.
The collusion need to be, see, the broker admittedly did something.
And the list was provided by the SFIO. In this list, the name of the assessee appears, my lord.
No, my lord. I have replied to the 148 notice.
Madam, please, madam, don't give running commentary. Mr. Sharma,
my lord,
true, Serious Fraud Investigation Department has conducted the investigation and investigation on the brokers in all probabilities and found certain transactions are bogus. In that, the name of the assessee features.
Features as beneficiary, my lord.
As SFAO can only investigate. You will have to establish, to make an addition in the hands of the SSC, you will have to establish that he colluded, he was part of the transaction.
My lord, here the kindly come to page 14, my lord, the assessment order.
But madam, why
Yes,
your SSC did not produce did not appear at all? He did not produce any documents.
I have replied to 148 notice, my lord.
I have replied, I've asked for the recorded reasons. That has not been provided, your lordship. I have the physical copy of the reply.
But where does the AO record that?
My lord, the AO's observations are page 14, my lord.
No. What they
That
say
is not there. No, here the assessing officer observed that no reply was submitted by the assessor.
On 30th of March 2019, they have issued the 148 notice for assessment year 12-13. 30th of May have asked for recorded reasons as to how the reopening has been made. That till date has not been provided, your lordship. I have the physical copy, your lordship.
Did you raise this point before the tribunal? In the grounds, you please see.
Ground is page 38, my lord.
That is not raised.
It's about reopening.
No, it's vague. Grounds are vague.
This ground is not taken by the assessee.
But Madam, you please come to page 33, para 6.2.1, last 5 lines. Subsequently, recess recorded for reopening of the assessment was provided by the AO to the appellant, and also statutory notice 143.2, 142.1 issued. Noted the appellant has not responded to these notice, issued show cause notice which was duly served, seeking and clarification on the issue. But they say they gave a request for supplying the reasons, and it not
Yes, my lord. Yes. That I can send.
all right. You get instructions on that point, Mr. Sharma. Huh?
My lord, I shall take.
You have heard so and so, so and so. Apart from the grounds which are canvassed before the tribunal by the assessee, the learned advocate for the assessee submitted that after notice was issued for reopening of the assessment, the assessee by letter dated
30th of May 2019, Your Lordship.
2019, 30th of May 2019, made a request for supply of the reasons which were recorded by the assessing officer for reopening of the assessment, but reasons were not furnished. In the assessment order, there is no mention. In the assessment order dated 13/12/19, there is no mention about on what date the notice, what date the reasons were furnished. However, in the appellate order, there is an observation in paragraph 6.2.1 that reasons recorded for reopening and statutory notices under 143.2 and 142.1 were issued. However, the date on which the reasons for reopening were furnished to the assessee has not been mentioned. In this regard, the learned advocate for the appellant department is directed to get written instructions from the assessing officer as to the date on which the reasons for reopening were served on the assessee and proof thereof. Next.
I'm
number 23.
Who will appear for 23, sir? Anybody?
23.
23.
The respondent has been served.
Yes, my lord. Delay was condoned, my lord.
But they didn't appear.
No. My lord, let be taken up. This be taken up on some other day, my lord.
All right. After vacation. Next.
I'm good.
Item number 24 is already, my lord, attached with item number 5.
5. Yes. So we will stop with this original side and we will go to appellates.
24 was will be taken up with another matter, my lord.
Yes, yes.
5.
Item number 5.
Your Lordship, I'm seeking leave to mention one matter in respect of appellate side. The contempt application, item number 34. In that item, Your Lordship, the main application is recorded as wrong. WPAP 180 of 2024. Correct will be WPAP 180 of 2024. Ankur Sharma.
You please write and give to the ACO.
Yes, Your Lordship, I'm deeply obliged.
Appellate side matter. Item number 1 to 29.
My lord, these are the matters of the Damodar Valley Corporation matters. My lord, am I audible, my lord?
Very
My lord, it is my application, my lord. It has come
My
up at
lord,
my instance.
I am led by Mr. S.N. Mukherjee, my lord, in this matter, my lord. Today,
As a matter of fact, this matter
Today,
is marked at 2 p.m. We are led by Mr. Anindo Mitra.
my lord keeps it. If my lord kindly keeps it tomorrow, my lord.
Sir, one thing. As of now, this bench does not have jurisdiction for Group 9. If it is a
My lord, this is a modification application.
Out of a pattern matter by your lordship. Well, in which they are
My
fighting.
lord, this is a modification application, my lord, of my
Clarify
lord's
the
order,
position
my
at
lord.
2 p.m. No problem in it.
No.
My lord,
We shall clarify the position at 2 p.m.
my lord, on 8th of April, my lord had passed an order, my lord. My lord, some consumers, my lord, had filed an application for modification on 8th of April, which my lord was pleased to observe certain directions, my lord, pass certain directions. My lord, thereafter, some of the other consumers have come up with certain modification of my lord's order.
Why
on
he
8th of
saying so
April.
many things? I will request to Rush to take it at 2 p.m. because it is listed.
Wait, sir, 2 p.m. it can't be taken up.
My lord, can it take up tomorrow, my lord, in this matter?
The prayer in the application is to restrain the appellant, so and so, the representative from taking coercive steps for recovery of late payment surcharge. This is not for modification at all. It is for an individual.
My lord, one application is for late payment surcharge. My lord, I am deeply obliged.
We shall
And my lord,
clarify
there's another application
kindly
filed by one of the another
time, my lord. I
consumers.
would request your lordship, my lord.
All right, list tomorrow.
Deeply obliged, my lord.
Tomorrow.
My lord, I am Proshun Mukherjee appearing for
Tomorrow 2
Damodar
p.m.
Valley
hobe to.
Corporation, my lord.
My lord, I have an application which is item
Led by
number
Mr. S.N. Mukherjee, my
5,
lord.
which is for precisely the same prayer which has just been said by your lordship, my lord. No coercive steps been taken because I have paid the entire arrear dues. It's not a question of paying 50%.
Tomorrow we will take it up.
Deeply obliged, my lord.
And my lord, the appellate has passed such an order in respect to some other consumer. So I'm praying for the same order.
My lord, will kindly take up these matters tomorrow, my lord. My lord, deeply obliged.
Next.
Item number 30.
Tomorrow.
Item number 30.
I'm Proshun Mukherjee, led by Mr. S.N. Mukherjee and Mr. Deepak Agarwal, my lord, for Damodar Valley.
Please ask your junior to give the slip. The names will be entered. Mr. Mukherjee is here.
Yes, my lord, I am here.
We'll record his appearance. Yes. None.
Item number 31.
31, not today.
31, my lord, I was appearing for my lord, I was appearing for respondent number 44, 45, 47, and 48, my lord.
No, that is a batch matter.
No, my lord, item number 31 is a separate individual matter.
31, how many respondents are there? No, this. What is the MAT number, MAT?
My lord, the MAT number
It's 93.
1863.
No. 30 or 31.
You give the appeal number.
Yes, my lord.
There are.
Mat number 1863.
You are appearing for which respondent?
My lord, I am appearing for respondent number 44, 45, 47, and 48.
That is Calcutta Tramway Company.
Yes, my lord.
Okay, that is MAT number 1863.
Yes, my lord.
Even on the last occasion, nobody appeared for the appellant.
My lord, we are for the respondents, my lord.
31.
My appeal, my lord.
Yes, sir. All right. Now the learned judge has referred to another single bench judgment in WPA.
Yes, my lord. May I just indicate that, my lord, that issue, my lord, a scheme was asked to be framed in that writ petition. My lord, we had initially framed a scheme that was accepted in the contempt, but subsequently, my lord, it has been held to be a sham. We had preferred an SLP. There is a stay. In that matter, there is a stay. Thereafter, there was further direction in the contempt. Again, my lord, we had preferred an SLP. There is a stay. So I was only praying for the timing, my lord, because issues are interconnected. Issues are interconnected.
Okay.
My lord, only thing they are pressing for the contempt in this matter. According to my lord,
you tell the court that stay has been granted by Supreme Court.
Another, but not related to this matter.
Then you should have filed tagged this matter also with that.
But I'm giving that number, my lord. I'm giving that number. Both these matters may be taken together. I have come with all the orders of the Supreme Court and the High Court.
Who appears, Mr. Tanay? Who appears for the respondent?
My lord, he was appearing, my lord, today. Possibly the list, the information has come to us.
Yes, yes. We will say not today. Just we will say not today. Let it come. In their presence, we will pass this out.
My lord, my lord.
My lord.
Item number 32.
My lord, item 32, I'm appearing on behalf of the appellant. My lord, there is a application for section 5. Delay is of 20 days, not 28 days, which was inadvertently written in the application. Para 7, page 7 is my explanations. Order was passed on 1st October 2024. Period expired on 31st October. Court reopened on 4th November. A certified copy was applied on 21st November.
Respondent has been served?
Yes, my lord. In fact, they have appeared. This matter earlier appeared before courtroom number 11 and the Honorable Division Bench of Justice Chakraborty.
Then why was it?
My lord?
Why was it adjourned?
My lord, it was adjourned because the memo of the appeal was erroneous.
Okay.
Yes, defect. Now this defect is cleared.
Okay.
So, if your lordship kindly condone the delay, yes, I can place the memo and stay application.
We have heard Mr. So-and-so, learned advocate for the appellant, and Mr. So-and-so, the learned advocate for the respondent. In terms of the directions issued on 17/12/2024, the defects pointed out by the stamp reporter have been rectified. There is a delay of 26 days in filing the appeal, 28 days in filing the appeal. As the explanation offered is acceptable, the delay in filing the appeal is condoned. List the appeal for admission after vacation.
Grateful, my lord.
Item number 33.
33 is our appeal, my lord.
My lord, I am respondent in person, my lord.
There is a delay of 232 days, my lord. We have explained that. The respondent, my lord, filed a longish applications by opposing that no, that the grounds which has been mentioned in the delay application is not justified and proper, so it ought to have been dismissed. In the section 5, lordship will find, my lord, we have categorically mentioned, my lord, this order has been passed in June. Thereafter, he has filed a review application. After, in August, my lord, in December, he obtained the review application. Thereafter, we filed our we filed necessary application for certified copy and all. We get the same on 22nd of January and 24th of January, my lord, we filed this appeal along with the section 5. And he is opposing by saying that state has unnecessarily delaying that and all this. There is a delay of 232 days, and if his lordship calculate that 6 months, then it would be only 132 days.
Matter relates to pension.
Lordship. And that issue is concerned, my lord, that has to be dealt with by his lordship, my lord, because it's a serious issue with regard to the fact, my lord, that in terms of the notification issued under Article 162 and 163, my lord, the persons who has been engaged as the confidential assistants of the ministers whose posts are limited only for 5 years, my lord, who are entitled to get pension in terms of a notification issued in 1996. Subsequently, my lord, under Article 163, my lord, that notification has been cancelled. And 2013, that has been cancelled. He sought for pension that he has worked for more than 2 years, that is in 1996 notification. And in terms of the DCRB rules, lordship knows, my lord, that has been prepared under Article 309, my lord, wherein, my lord, it has been categorically mentioned a person ought to have been worked 10 years continuous service. Then only he will eligible for pension. So this is the entire germen of this issue, my lord. So what I respectfully submit is, my lord, and I was told, my lord, Learned Advocate General also address this issue because it's a serious issue with regard to the fact, my lord, a person working for 3-4 years is entitled to get pension, or a person working for 10 years. There should not be any disparity with regard to these pension schemes, my lord.
What do you say, sir, Mr. Das, about the delay?
My lord, My lord, my humble submission is that this appeal is nothing but a helpless effort to avoid the dire consequences of contempt of court by the appellant. And moreover, my lord, apart from everything, on oath, they have submitted false averment in their reply to my opposition. That my lord, in paragraph 4E, page 5 of their reply, my lord. I have so many things, but this is enough, my lord, that in objection, reply to my objection. Paragraph 4E, page 5, my lord. It is also stated that the appellant had in fact attempted to mention the matter before the Honorable Division Bench presided over the Honorable Chief Justice sometime in January 25, praying for leave to file the memorandum of appeal against the judgment dated 21st May 24, passed in connection with WPA 26316 of 1220. Although certified copy of the order has already applied for. However, as the certified copy of the judgment was not yet available, with the appellant at that stage, the mentioning was not entertained by the Honorable Division Bench. So it is a totally false submission, my lord, because, my lord, they have applied for certified copy on 16th of January. And they have filed the memo of appeal, my lord, on 22nd of January. So in between, only 4 days, my lord, court has opened, my lord. That is 16, 17, 20 and 21. My lord, the live streaming of the entire proceeding of my lord's court is available in the public domain, that is in YouTube. And I have checked, my lord, several times. Nothing was there that they have applied, they have mentioned the case for filing the memo of appeal without certified copy. And my lord, being a student of law, I know that this is a clear violation of this is a crime. This is a crime against justice under 215 of BNS. And I am seriously considering to file an perjury application against the officer concerned and the advocate on record also for submitting false affidavit before the honorable court for diverting the court. And my lord, I have so many things. I can, if my lord can give me permission, then I can explain the actual fact, then the law and supported by Supreme Court judgment, my lord.
Then what we'll do is,
my lord,
we'll list the matter immediately after vacation.
My lord, don't do it, my lord, because I am suffering
because
from
this side
last
of the
13
vacation
years,
is
my
no
lord.
time, my lord. Let it fix after 1 week after vacation, my lord. And my lord, we will address before his lordship, my lord, on this
My
point,
lord,
all these points.
my lord,
Because the principal issue is very serious in nature, my lord. The issue involved in this matter, that I have explained before his lordship.
What the petitioner appearing in person says, that this averment in the reply affidavit is a false statement.
My lord, my junior is Amrita Panja Maulik's junior was mentioned this matter before his lordship for obtaining leave without the certified copy, which has been turned down. Somehow, my lord, that has not been live streaming or not, that we don't know. But
my lord, everything is live streaming, my lord.
She has said,
my lord, coming to the court and going out from the court,
so many
everything
things,
is on
but
public domain,
we
my
cannot
lord.
deny an advocate herself present here and says, my lord, that her junior is specifically instructed and accordingly she has mentioned that, and this is, my lord, this is not the ground for delaying of 232 days delay. We have attempted, my lord, to file this matter. My lord.
The petitioner appearing in person wants the matter to be heard. This side petition. Probably now, Mr. Pathak, on what date this side matter will come in this week?
My lord, kindly do not fix this week. I have some personal request. Kindly takes up 1 week after vacation, my lord. I will, because this week, my lord, I might not come to court, my lord. That's what, my lord.
My lord,
That's
last
the whole
time
problem,
also
my
they
lord.
have taken time, my lord.
No, but that is not taken time, my lord. How we have taken time, my lord? Unnecessarily, he has made an objection on section 5, and if he do not, my lord, then the matter would have been decided on merits, my lord. And the point involved in this matter, I have explained before his lordship.
My lord, there is no
And my lord, on the
question.
last occasion in section 5, application has been elaborately been heard. The other bench has only directed us to show us any judgments.
Mr. Utpal Das,
My
we'll
lord,
list the matter in same position on 9th June.
Lordship,
my lord, please heard it before. My lord, I am waiting
Kindly, my lord.
since 15 years, my lord. I am waiting since 15 years, my lord.
Heaven will not fall within 15
Last
days.
time
ma'am.
also, my lord, this is nothing but a dilatory tactics, my lord.
Now item number 34.
Get full lordship.
Next.
এই order হলো তো? And নামটা দিয়ে দে।
Item number 34. Item number 35.
35, Your Lordship, I appear for the Union of India.
I am for the appellant.
34, not today.
My lord, I have come before your lordships
Oh.
with a challenge.
35, Your Lordship, I appear for the Union of India.
Yes, madam.
My lord, I kindly come to page 57 of my stay application. There is a dismissal of the writ petition on the house first day without calling for the affidavit. What happened in this case, my lord, I have applied for the post of general duty in CAPF examination conducted by the SSC for the year 2024. I passed the written examination, qualified for the next step, PST, my lord, physical standard test and PET and medical examination thereafter. My lord, at the time of PST, I have been declared, my lord, my candidature has been rejected on the ground of shortfall of height. My lord, I wish to prefer an appeal on that point, on that rejection order, but they have sustained me from preferring appeal. Thereafter, I send it through email on the very next day, my lord. Thereafter, my lord, the appeal was, the email was received but did not take any step. Thereafter, I come before your lordships by filing writ application, praying for a direction for my remeasurement on the point of that I have qualified earlier examination and I have the requisite height, my lord. Thereafter, my lord, kindly come to page 30 of my, my lord, 53 of my application, stay application. Kindly come to page 53 of my stay application. This is a fit certificate on the physical standard test for the year 2022, which was conducted on my lord, May 2023. My lord, in that event, my lord, first column, my height was given and shows 170 centimeter. That is the required height measurement. My lord, this year, I have been shortfall for, I have been measured, my lord, as, my lord, 159.7. Although this qualification, this measurement, also, my lord, the should be round up in the next higher level. My lord, page 48, the rejection order, page 48 of my application. Page 48 of my application, stay application. This is the rejection order. My chest has been measured at 78 centimeter normal and 5 centimeter expansion. It was measured more than I have expand my chest 85 centimeter. And then the height qualification. Height has been measured, my lord, 169.7. That should be round up with the next higher.
But the learned judge says.
Learned judge says it may be in height qualification I can be, but in the chest measurement I should not be. My lord, I have shown your lordships. Kindly come to page 53 once again. 53. Last column, my lord, last column.
The 50.
My chest measurement, page 53.
This was the last earlier selection, is it?
Last year examination, I have been measured. My lord, last column 80 and 85. The chest measurement was taken on just 6 months prior to this examination.
But
My lord, that's why I prayed for the further direction for measurement my chest. My lord,
No.
that is all my prayer.
Wait. Under the notification, is there any provision for re-verification? Because let us assume that is writ petition is filed for re-evaluating answer paper, answer script.
Yes.
Earlier courts were issuing directions. Now the Honorable Supreme Court has said, unless and until the guidelines or the notification provide for that, a writ court should not direct re-evaluation.
I bow down to your lordship. In the employment notification itself, it has been mentioned that if a person aggrieved with the first instance, that is the measurement of height and chest, he can apply for the remeasurement on the same date.
Please show that notification.
Yes. That my lord, the rejection slip itself shows. My lord, I have referred my lord page 48. Once again, kindly come to
satisfied with the ground of
well, column one. If you are not satisfied with this, my lord, this provision is there.
All right. What happened to your appeal?
My lord, I wish to prefer this appeal, but they have driven out from the campus. It is the practical scenario. My lord, thousands of candidates are present in the campus for measurement. They have created a chaos. My lord, thereafter he rushed and driven out from the campus. Thereafter, I preferred this appeal. My lord, kindly comes to page 50 of my application. This appeal I have preferred and send it through email, page 51 and 52, my lord.
And no response.
My lord, no response has been given, my lord. That is all about my case, my lord. And there are some vacancies is still vacant. My lord, I may be directed to any other person, any other agency to remeasurement my height and chest, my lord. That is my all.
Madam, what is your instruction on this appeal memo?
Yes, your lordship, my instructions in this are that time and again he has been found unfit in terms of not only a few centimeters but more than a few centimeters, which completely disqualify him, your lordship, in this regard. Which is why under the guidelines we are not being able to relax the requirement.
He doesn't want relaxation. What he says is he participated in a selection 6 months back, where his chest measurement qualification he was found to be qualified. Your rejection says if you are not satisfied with the ground of rejection during PST, then you may prefer an appeal. Let the appellate authority take a decision in that.
Absolutely, Your Lordship, but they had not preferred an appeal at that point.
No,
Instead, yes, Your Lordship.
They have one communication is there at page 50, then followed by email communication, which page 51 and 52.
Your Lordship, there is a prescribed pro forma under which they are to apply, Your Lordship. They have to apply as per the prescribed format. They have not applied as. Therefore, they have not gotten a response.
Where is the prescribed? Is it forming part of the notification?
It is mentioned, Your Lordship, as part of the guidelines. I can produce it on the next date, Your Lordship. However, Your Lordship will kindly give me some time for this because, Your Lordship, currently I am out of the country, Your Lordship.
My lord,
that is my difficulty.
Then, my lord, I should
advantage of having video conferencing. So
I understand, Your Lordship, but I want to place those papers before Your Lordship, and my juniors don't have access to it. That is the only difficulty.
My lord, may I pray for one thing, my lord? Then, my lord, one interim order should be passed because they will then again say that no
kindly does not pass the interim order,
no
Your
such
Lordship. They have
vacancy
time and again come and appealed, and they have always lost in the appellate court.
And the learned advocate appearing for the respondent department. The petitioner, the appellant filed the writ petition seeking for remeasurement of his chest measurement on the grounds that when he participated in the earlier selection, his chest measurement, the chest measurement taken was within the prescribed parameter. The appellant would submit that in terms of the order of rejection dated 28/10/2024, a person who is not satisfied with the ground of rejection during PST may prefer an appeal to the appellate authority. According to the petitioner, he filed an appeal on 1/11/24. However, and the same was all sent through email on the very same date. In this regard, certain documents have been annexed in page 50, 51, and 52 of the state petition. The learned advocate appearing for the respondent department is directed to get written instruction as to whether the said appeal petition was taken on file and whether any orders have been passed. And if not, for what reason orders were not passed in the said petition. List the matter. You give a date immediately after vacation. When do you want it, madam? When are you back?
Lordship, after vacations, Your Lordship, kindly.
We can have it
On 11th or 10th or 11th, my lord.
On 16th June.
My lord, in
I'm
that
so
event, my
grateful,
lord,
Your
kindly
And no, Your Lordship, Your Lordship
interim
will
order, my lord,
kindly
one
not
post may be
because they
kept
have
vacant
time
for
and
the till
again,
the
Your
date,
Lordship,
my lord.
before different benches requested, but they have not been granted an interim order only for this reason that they are not qualified for it.
You are in the next case, madam.
Item number 36.
Lordship, may I be permitted to mention the previous matter, Lordship, 34 I have missed because I was in another court, Lordship. Lordship, I am praying that the matter be taken up tomorrow.
We said not today.
Lordship, I was not here, Lordship. I apologize.
No, we have said only not today. You verify.
Grateful, Lordship.
Yes, next.
My lord, item
36.
36, my lord, I am appearing for the appellant, my lord. My lord, appeal has been preferred, my lord, by the Ministry of Textiles, Union of India, my lord. My lord, the main grievance is that, my lord, whether the appointment to the post of Chief Managing Director.
Yes. Why was it mentioned
my
last?
lord, my lord, kindly peruse the dates, my lord. I am pressing the dates, my lord, where the advertisement was floated, when he applied for the premature retirement, my lord. My
No,
lord, the dates
we'll do one thing, sir. We'll take it up in a physical hearing. Let the matter remain in the list.
My lord.
Tomorrow it will come.
Tomorrow, my lord.
You ask the ACO, we will tell you.
My lord, I am grateful, man.
Item number 37.
37 and 38.
Well, item number 37 and 38, my lord, I am appearing for the appellants. But this relates to, my lord, appointment of Civil Judge Junior Division. With our specific case before Lordship, my lord, the select list, which has been finally prepared by the authorities, respondent authorities, is in contravention of the law or the procedure laid down in Malik Mazhar Sultan 3. Well, what they have done, my lord, may I just take your lordship briefly?
All right, we'll take it up immediately after vacation.
Tomorrow or day after, my lord?
No, after vacation we'll take it up.
My lord, only there is some urgency because, my lord, the post vacancy position.
Vacancy position is yet to be drawn.
My lord, then we come back on reopening then.
Reopen. Both matters.
37 and 38.
31 I have the state responder.
Yes, sir. Next.
Item number 39.
Reopening date. On the reopening date.
39.
Item number 40.
My lord, I am appearing on behalf of the appellant insurance company in this case. My lord, I have come up against an award passed by the Learned Commissioner, Employees Compensation. My lord, where is my lord, Learned Commissioner, my lord, against the statutory provision, my lord, has directed the insurance company, my lord, of the involved vehicle to make payment at the first instance to the injured claimant. But I have come up before your lordship, my lord, under the Employees Compensation Act. My lord, the liability of the payment of would primarily fall upon the owner of the vehicle or not upon the employer. Insurance company is to reimburse. But I am agreed, Learned Commissioner has asked me to make payment at the very first instance on behalf for the reason that I have issued the insurance policy.
Suppose you are given the benefit of pay and recover. Will you be satisfied?
Milord, pay and recover. No, Milord. Milord, in this case, Milord, there is another angle. There is an angle of fraud as well. Milord, the claimant has already received compensation, Milord, under Motor Vehicles Act. And Milord, again, he has come up for the second time, Milord, to take advantage of, Milord, the Employees Compensation Act. There is the second angle. But, Milord, on the first issue itself, Milord, when my Lord has been kind enough, Milord, to pose the question of pay and recover, Milord, in this pay and recover, Milord, would not be, Milord, is not there in the Act itself. Milord, this pay and recover is under the Motor Vehicles Act.
Correct.
Motor Vehicle Act, Milord, the policies are statutory policies. Milord, these are not statutory policies in Employees Compensation Act. These are contractual policies. And Milord, under the contract, Milord, I am supported by at least, Milord, 4, Milord, coordinate bench. Milord, am I there, Milord? Yes, Milord, I am supported by 4 coordinate bench judgments of this honorable court, Milord, wherein the substantial question of law, Milord, has been, Milord, framed that whether insurance company is primarily liable or not, and honorable division benches have held that no, insurance company is not primarily liable. It is to be paid by the owner or the, Milord, the employer, and insurance company is to reimburse. Milord, on those score, Milord, I was humbly praying before your Lordship. Milord, your Lordship will kindly, Milord, grant a stay of the award in question, and Milord, let this question, Milord, be posed before the learned honorable single bench. Lordship.
No, already there is an order of stay. In view of the submission, the execution proceeding pending before the learned commission shall remain stayed for a period of 4 weeks or until further orders, whichever is earlier.
Milord, your Lordship will kindly, Milord, substantial question of law was not framed. Milord, this question of law, Milord, I was humbly beseeching your Lordship will kindly frame, and Milord, transfer the matter before the honorable single judge to decide this issue, Milord.
But what did the learned single judge do?
Milord, learned single judge, Milord, on the last day when the matter was learned single judge, Milord, the substantial question, Milord, is whether insurance company under this Employees Compensation Act becomes primarily liable to make payment at the first instance to the claimant.
Said, sir, that you have said, and you have relied upon a division bench judgment of Justice Dipankar Dutta and Justice Munshi.
My Lord, this is one of those 4 coordinate bench judgments. This is one of those.
No, what happened to your writ petition?
Milord, writ petition?
No, this is directly before the division.
Milord, this is appeal. This is appeal, Milord, against the award passed by the learned commissioner, Employees Compensation. Milord, paragraph 11, my Lord has referred to the judgment. Your Lordship will kindly have a look, Milord. Substantial question of law was framed.
Let us see your memo of appeal. Where are the questions suggested? The respondent has been served.
No, Milord, respondent has not been served, Milord.
Then what, in his presence, we will frame the question.
Lordship?
In his presence, we will frame the question.
Milord, in his Lordship wants the Milord respondent to be served, and then I come back to your Lordship, Milord.
We will extend the interim order until further orders.
Lordship, not till further orders. Extremely grateful to your Lordship.
And then
I'm deeply obliged. Lordship, kindly.
Also, learned advocate appearing for the appellant insurance company. It is submitted that a substantial question of law arises for consideration in this appeal. And where have you suggested this question of law?
Milord, paragraph 11 of the judgment, Milord, which my Lord is referring to, this coordinate bench judgment, Milord?
No. In your memo of appeal,
in the memo of appeal,
the question of law, you have not done so.
Milord, in the memorandum of appeal, Milord, I have stated in one of the grounds, Milord, the insurance company is not primarily liable to make payment, and the payment, if any, has to be made by the owner of the vehicle. Milord, this is what the ground of appeal is. Milord, if I can just indicate to your Lordship, Milord. Milord, the ground 3. Milord, ground 5, ground 8. Ground 8, Milord, is a little more specific. It's always the responsibility of the Milord, the owner.
All right. It is submitted by the learned advocate appealing for the appellant that substantial questions of law arise for consideration in this appeal. And one such question would be whether or not it is the primary liability of the insurer to compensate an insured workman, and whether the commissioner would have directed the insurance company to settle the claim. It is submitted that this issue was considered by the division benches of this court in earlier decisions.
Lordship.
And the question was answered in favor of the appellant company, the insurance company. holding that the primary liability cannot be thrust upon by the on the insurance company by the commissioner.
Grateful to my lord.
In this regard, reference was made to the decision of the Honorable Division Bench in the case of United India Insurance Company versus Amal Kumar Ray and others. Manu WB/0276/2017. It is submitted by the learned advocate appearing for the appellant that there are other decisions of the coordinate bench on the same point, which fully supports the case of the appellant.
My lord.
As could be seen from the order dated 2/4/2025, the Honorable Division Bench directed the stay of the execution proceedings pending before the Commissioner for a period of 4 weeks or until further orders, whichever is earlier. Considering the question of law which has been suggested by the appellant, we deem it appropriate to extend the interim order already granted on 2/4/2025 until further orders, and the execution proceedings pending before the Commissioner shall remain stayed. The appellant is directed to serve notice on the respondent, as also the learned advocates who appeared before the Commissioner, sir. Any lawyer appeared?
My lord, as far as my lord award is concerned, my lord, the name is not mentioned, my lord, of the learned advocate. But I'll serve, I'll find it out and I'll serve, my lord. I'll serve.
Also on the learned advocate
Lordship.
who represented the claimant before the Commissioner.
My lord.
This is the matter after. Give a date on the 2nd week of June.
All right. 2nd week of June, my lord. I'll find out the date.
Yes, you will give it.
Item number 41.
Grateful to your lordship.
My lordship, kindly not today.
Have you served notice, madam? Last occasion, the division bench passed order directing you to serve respondents by speed post.
Yes, yes.
Have you served notice? All right, at the request of the appellant, let's sit after vacation. In the meantime, service of notice on the respondent should be completed. Yes?
Yes.
Item number 42.
And I beg to appear for the appellant. This is a statutory appeal under the provisions of the Employees Compensation Act. Now,
in these appeals, Mr. Mazmundar, advance notice is not served on the claimant.
But we have served. But we have effected service with great difficulty. That persons were not to be easily found out. Then somebody from the local neighborhood said that I can accept the service. It's going on. And the learned advocate representing the applicant before the Employees Compensation Commissioner, he has also accepted service of the notice.
And who's he? Is he appearing today?
He is not appearing today.
And where is your question of law where suggested?
But we have got the affidavit of service prepared with us.
No, normally will you not suggest the question of law in the memo of appeal?
Yes.
See, in our state, we follow this Workman Compensation Act.
Why not? Substantial question of law is only to be.
We normally.
I'm not. Question is not a claim application has been allowed, holding that the accident arose out of and in course of employment without any evidence. That's the first issue. The second one would be not whether a normal death could be said to be not an accidental one.
And then what you can do is ask Victor Chatterjee to frame a question.
Why not?
In the meantime, let us see whether they appear on the next hearing date.
Only there is one predicament. With great difficulty, twice we had been succeeded. We had been persuading the commissioner not to disburse the amount which is lying in deposit. But kindly, we shall once again try to effect service and come back with a suggested question of law, not to be for the purpose of admission of the appeal. But if your lordships may give us a breathing space, not so that we can come back after the vacation and direct him not to disburse the amount. It's lying in deposit. It's returnable on 5th for the purpose of execution.
On 5th, is it? Okay. So if we grant stay, they will come and appear.
Why not?
We have heard Mr. Soumya Mazumdar, learned senior advocate, assisted by so-and-so learned advocate appearing for the appellant. Notice has been served on the respondents and affidavit of service has been filed. However, none appears for the respondent. The learned advocate appearing for the appellant submits that the commissioner, that though prayer has been made before the commissioner to now not to disburse the amount which is lying in deposit, no order to the said effect has been passed, and the matter has been set down by the commissioner on 5th June 2025 for disbursement of the amount deposited. Since this appeal is a statutory appeal and the court has to consider whether any substantial question of law arises for consideration, we deem it appropriate to grant time to the appellant to suggest the substantial question of law which according to them arises for consideration in this appeal. In the meantime, the learned commissioner, First Court Employees Compensation West Bengal, shall not disburse the compensation amount which is lying in deposit, and the same shall continue to remain in deposit till the next till 16th June 2025. Let the matter appear on 12th June.
Grateful,
under the same caption.
Grateful.
Two matters, sir.
That's similar matters.
Two matters. So
no, that's all for today, Manoj.
That's all. Mr. Debashish Kundu, your matter?
Item number 44.
So it will be taken up. Today I've got a video conferencing meeting at 1:15 it starts.
Lordships.
So therefore...
taken up in course of the day or tomorrow?
Tomorrow.
Leave the place.
This is Chatterjee, I think we'll close.
Lordship.
Yes.
Close করে দাও। Stop করে দাও।